for high GC news. Mima ubibia akwaba had the latest hot kwa era mede bremo. Eruti zonya subscribe to channel idea bo modia say over subscribe. The way say over click the subscribe button. Na wabele notification. We had sa video for be upload no. What the first person wants sa ebeka sa video. Afi uya na wa like video no give us a thumbs up na fi share ma wo foforo so na wenye bi hwe na wo hu ensemo a ekoso e wo Ghana memo hanum afin tentemara yembura ye ensemo a abeto ye pno so uminti ye sankomo ya babeto je sa report mama yiti sansemo ye ekoso uminti.
You have a situation where a political party makes a campaign pledge that I intend to fight corruption. And it was a major matter relative to its overall campaign, right? Mm-hmm. Then you also have a situation where the party says, I will do oral. Mm-hmm. Now, there are people who voted for the NDC, possibly not because they want bread and butter, but they felt that there was some level of unbridled corruption or whatever. And so that's all they wanted for change. That's a constituency you must also satisfy as a government. You will note that the Attorney General has been very cautious. After filing the charges, the comments have been very, you can see caution. But when he first addressed the press and revealed the extent of the investigation, it was nothing sub judice. Because at that time, he had not filed criminal charges against anybody that you can say that he will be in the realms of prejudice or anything. He is saying that as the chief law enforcement officer and the principal legal advisor of government, the investigators I have marshaled. This is what they are telling me by way of their investigation. And that the details look cold. The details look terrible. At that point, he is permitted by law to address the people. And I remember, my clients, when they were being prosecuted, Nanado went to the bar conference in Takrade. You remember the bar conference that happened in Takrade? And among, according to him, his efforts are fighting corruption. He listed Opuni and Thompson. This. He went through one after the other. I recall vividly. Godfrey Adame went to London, a public forum, and brutally attacked Opuni and Sedwa Gongo in the name that he was fighting corruption by way of prosecution. I have actually heard leading members of the NPP say that, John Mahama and his NDC, no mujamu omenum. They were bragging. They can't do FOKO. So if the Attorney General comes and say, look, contrary to the claim that we can't do FOKO, this is FOKO.
Well, the concern is that the court of public opinion will form an opinion based on what the AG says. First of all, how much of
justice
that plays a role
from who?
In the people.
Justice emanates from who?
The people.
Remember, no, hold on. Remember that we're supposed to be back to the Leviathan, the state of nature, where it is mob justice, might is right. However, at least we go back to the Hopeson, issues. However, we have all resolved that instead of us meting our justice to people, why not us allow a group called the judiciary to perform that role? Ordinarily, we were supposed to be administering that justice. So the Constitution itself recognizes, it says justice emanates from the people. The people must know. And that is why in advanced countries, even for criminal district, you still have your peers, by way of a jury or whatever, having a say.
How do you respond to those who say that no matter how watertight your case is, whoever is involved is innocent until proven guilty.
I have been an advocate. Look, for the past 8 years or 11 years of my law practice, I've actually been doing criminal defense, like my senior here. I've never worked for government or prosecution. I've all done criminal defense all my life. I've gotten people acquitted and what have you. So I am someone that I don't joke with that hallowed principle, the presumption of innocence, that the Constitution and its framers gave that constitutional endorsement to. So I am the last person to say you are guilty. No. But a prosecutor doesn't go to court to say the person I'm prosecuting is not guilty. That's the reason why you are in court. So you notice that even in the US, the advanced countries, when state attorneys go to court and they will address the press and say, this is the case we have put before the judge. And with the evidence that we have, we strongly believe that we can secure conviction. At the point that we should be clear that it is not persecution, but what? Prosecution.
Let me jump in a bit here, because on this point, I mean, I think that one of the things that we need to be able to credit the Ghanaian public with is that they have an interest and intelligence enough to be able to understand processes that are happening generally in the country. I believe strongly, irrespective of an accused person's right to innocence, that the public have an interest to be updated in the steps that the state is taking to deal with corruption in particular. And I believe any matter that, any cases or any documents that are filed in courts are matters of public, are in the public domain anyway, that the Attorney General is entitled to, on their website, provide us a list and updates of the cases they have filed and the stage at which those cases are. The big question about the innocence of accused persons is whether, in terms of the trial, there's process integrity. Whether you can go to court and that nothing within the courtroom would be obstructed or constructed in a way that presumes or takes your guilt for granted. That exists. I think it still exists. So, but the updates to the public, I think, are necessary for the health of our democracy. If anybody, or if this democratic project will lose its balance, is that the people who have come to assume and understand that no matter how much corruption public officials get into and involved in, nothing happens to them. We must know how to carry the people along for them to believe that the state is interested in going after and prosecuting corrupt offenses. So for me, I love and absolutely encourage the Attorney General to continue to give the public these kinds of updates. We ourselves are entitled to
like violence.
Yeah, we are entitled to be able to interrogate them. And in the same way, I must say, if this government was then in power and the next government came in, and public officials were said to have been involved in corrupt deals, I would want the next Attorney General as well to update us on what steps they are taking to prosecute them as well. So I am consistently pushing Attorney General to be absolutely ruthless in going after any individual who has been involved in corrupt cases. Well, and I believe that in terms of how ORA is constructed, that there has to be a website where we can all go and look. These are the number of cases that have been prosecuted. These are the number of public officials. This is the stage at which the cases are. That at least, as long as it does not detract from the fact that when a person shows up for trial, the person will then have the benefit of a fair proceedings, then that's fine.
I see, but you see, you acknowledge.
If you listen to my learned senior Attachia, just to clarify, if you listen to my learned senior Attachia, he created the impression as though the AG went to court without evidence. I think it's erroneous. What happened is that when an accused person, maybe during the investigation, is granted bail, one of the conditions of the bail, and in fact the lawyers in advocating for bail, usually what we say is that our client is not in position to tamper with witnesses or the evidence. And so for that matter, the court should admit the person to bail. Gracious. Now, what the AG is saying is that in this specific case, having been granted bail by the court, the accused person has taken steps, which steps, if permitted to allow or to proceed, would have the unintended consequence of influencing witness the person can go to and say, Menua, side the men Oko court now can. You understand? You are basically influencing the witness. You remember the Jakpa Attorney General conversation? Exactly. Because at this point, where for instance charges have already been filed, and you are calling a witness that help me make my case sweeter, that is witness tampering.
See, and that's what Atta said. He's not even going to call the AG at all. He will not have any phone call conversation because of this precedent. As the AG raised concerns
so
about,
I think we need to clarify it.
But you acknowledge the slippery path that the AG might be on, to the extent that yes, these public or continuous press conferences would update the public, but then again the public would also form an opinion because the public court of opinion will be at play. But then you would have to also prove beyond reasonable doubt that what he has said in these press conferences hold in court. Because proving guilt in criminal cases, it's not a walk in the park. You know this, and this is not for me to say. So that is where the concern is to that extent.
Yes, listen. There are two things that happens when the AG addresses the public. That what he's saying is that this is the evidence we have gathered so far and that we are taking to court. It allows the public then to be able to form an opinion or dispel a notion whether or not these prosecutions are politically motivated or not. We must remember that it is oftentimes in terms of the level of corruption we're talking about, it's usually politically exposed persons. Persons with significant power and resources in terms of media, in terms of how they form and move public opinion. And so we are interested in knowing that the Attorney General is not going into court on frivolous grounds alone. That the public is entitled to know. Now, if the Attorney General, while the prosecution is going on, after every day in court comes to the public and says that this is the questions I asked, this is how he responded, things like that, I don't think it's proper. But as to whether or not, at the point decision is made to charge a person with a crime, this is why we have arrested this person. These are the basis of the evidence on which we are going to court. The person will be entitled to their defense. Nobody has ever assumed that once an Attorney General presents a matter to the public, then it's done deal. Everybody understands it to be tested in the courtroom. Again, I say that we cannot create a society whereby we think that technicality of the legal and criminal proceedings and criminal justice system must be removed from the public. They must be carried along through a process of public education. And that process of education tells that when Attorney General says, okay, we have done rigorous investigative work. This is the evidence we have gathered. Our task now is to go to court and prove their guilt beyond reasonable doubt. An accused person is entitled then to be able to poke holes in our case. But our job is one of diligence. And our job, like is consistently said, which I agree with, that I am not going to court unless I have gathered the evidence that leads me to believe that I will secure conviction. I think that is important. Now, particularly in this last point, particularly in our jurisdiction, whereby the vast majority of cases that we try are done before a judge and not by a jury, where you say that there's possibility of jury contamination, then the risk is even lower than we think it is. That's why I'm saying that whether or not in terms of the criminal trial itself, is there process integrity? If there's process integrity, an update to the people in a democracy, as it happens in so many other democracies, is nothing that will create alarm bells. And in fact, there's nothing that he has said so far in any of the press conferences that I'm like, okay, this is treading beyond where you should be going.
Is there process integrity? That question you asked.
Yeah, I mean, there's nothing that they have said so far, even in terms of the accused persons, said that they have gone to court and they have been denied certain rights. Indeed. In fact, the conversation we have been having around process integrity is these conversations around disclosures, which our laws did not allow. Now, if anything within our law do not allow them to be able to assess a fair trial, they have the right to be able to push those as well.
Okay.
You know,
the point is that while we are not saying that, or I'm not saying that the Attorney General briefing the public is not right, but the point is that if preferred charges have been leveled against the accused persons, the Attorney General can come out and say that this person has been arraigned before court, these are the preferred charges, and give all the issues thereof. But before that, if a commentary is run, this person, he has this house here, he has taken money from this place, he's done that, he's done that, he's done that, I feel it is more in law, and just opposing it to Article 19, it is more of brandishing the person in the minds of the public as guilty.
Is that so?
Yeah, as guilty, because the public forms a perception, and that perception is what deals with the innocence of the person before the court even pronounces the person as guilty.
But what's the consequence of the public perception and what happens in court?
Did you watch O.J. Simpson's?
Yes. The point is updating the public is good. Updating the public is good, but that update, when it comes just at the time that the accused person or the suspect the charges has been leveled against that particular person and you are briefing the public, that is factual because that has been done. But not when you are in evidence gathering. That process is not completed. And then you hold a press conference and you make it known to the world that this Mr. A has done this, he's done that, he's done. Before preferred charges are brought against that person, that is where my legal problem is. But not that updating the public about the truths and the not.
But the Supreme Court itself had been sitting sometimes with television, out there. Like I always say, justice delivery itself is supposed to happen in public.
Yes.
Unless it is exceptionally provided for, then you can do in camera. Yeah. So, in fact, nothing precludes our courts, in order to assuage victims of crime, to allow them to watch the process. It's also part of, sometimes even letting the victims of those crimes feel okay, that justice is being done. So they sit through the process. They go through all that process. It allows even for victim, offender-victim relationship and even making it better. Because there are times that when you see this thing happening, the public is say, oh, our judges are doing well. Because you see, the public doesn't know what the judges possibly do in the courtroom. That is what influences. But if the public sees, oh, the judge, evidence was taken, the cross-examination is what exposed the loopholes in the case, the public immediately begins to form its mind. But when the public is kept in the dark, and eventually a verdict is returned, that say, oh, the person is not guilty, then the public is say, but say, I say, A, B, C, D. Now, Cecilia, I read it, no buy. This is what they are saying. So sometimes it's in our own interest, even for the accused person, to see your lawyer punch holes. In the case of the prosecution, for the entire public to see.
Okay. I think we all agree on the fact. But it's talking about the timing of the presentation of the evidence. I think we all agree on the fact that there should be updates to the public. But the timing is the thing. My point is that the timing should be when the charges have been preferred, not when all those things have not been done, and yet you come to the public, I've gathered this evidence, I've gathered that evidence, and you try to run it in the public. Let evidence be gathered, prefer the charges against them, and then when you are giving update to the public, it becomes very concretized.
Okay, on this particular position, as to whether the AG is on a slippery path, as the lawyer Christian Mamhese is saying, the timing of coming out as against what he says at the press conference.
Good. So let's come with lawyer Chris Mal. Yes, you see his last point. He says he wants only concrete facts. You remember the previous update the AG gave before this one? He made it clear. He gave out only those parts he had finished investigation. Then there were other parts where he clearly said, we've not followed these lines of inquiry, so I don't intend to go there. He was very clear. Oh, but Ayine is an astute lawyer, somebody who is taught all of us here across. Maybe you didn't meet him. All right. Ayine is an astute lawyer. You can tell. Your lecturer, if he's good, you can tell. If he's struggling, Ayine knows stuff. I mean, this is elementary. You don't expect Ayere to come and tell you speculative stuff. So he himself said it, that, look, I talk about only matters I've concluded investigations on. Those I have not, I will not touch them. This is basic. And like counsel, you see, this matter, as I've said, for us, the time we're very young on, I still can picture the O.J. Simpson trial and all that. Yeah. So that's what we've grown up with. So it's too late in the day, long before I contemplated going to law school, I saw these things on TV. And so, I mean, you go to America, day in, day out, the DA, the district attorney. Upon the this is what a case happens, they are looking for the suspect. Even when they've not yet found him, the DA is constantly holding press conferences and giving updates.
You know, they elect the attorney generals. Yes. So the attorney generals have a responsibility to their constituents to update them.
Yeah. That's a district attorney. Yes. That's a DA. And that's where we live. I mean, I can picture this is America. You live there, you see constant DA is on TV. This particular matter, we are looking for the individual. He's within this area. Even sometimes they can tell you, we are circling on him. He's within this area. It's just commentary, running. So perhaps it's our society, because I mean these are things we have grown up with.
In fact, I would have wished that the former Attorney General had put this treason case against me to the public. For the public then to see what
how ridiculous
the ridiculousness of
but you saw how he finally fell. You saw the leak tape. You see when the man is very mean, very mean. You see he gets his downfall. You see how the leak tape now will go before Godfrey Dami for the rest of his life. When you want to use the justice system for political ends, that the finance minister and Akufo Addo are on his neck. Finance minister and Akufo Addo are in his neck, and you saw how finally he embarrassed himself for the rest of life. Because sometimes, like, hey, Godfrey Dami, you and this leak tape, how are you going to come into court? How are you going to relate to us?
Well, but he still goes to court.
Anyway,
this is one point that the Attorney General also made. In updating, he says he's going to prefer separate charges against Kwabena Agyapong on the latest relating to the Ghana Water Company Limited deal. So 1.5 million that was being paid into his private account every month for the said supply of internet services to Ghana Water Company Limited. This is what the Attorney General said. Take a look.
This criminal enterprise involved the purported provision of secured internet services to Ghana Water Company Limited by the erstwhile Bureau of National Communications, now National Signals Bureau. The contract document showed that Ghana Water was to pay BNC, that is the national BNC, the sum of 650,000 Ghana cedis every 2 weeks for secured internet services from BNC, that is the Bureau of National Communications. However, for purposes of the payment, Kwabena Agyapong provided the account details of his company, BNC Communications Bureau Limited, to Ghana Water, which religiously paid for the internet services. In other words, every 2 weeks when 650,000 Ghana cedis of money from Ghana Water left the bank accounts of Ghana Water. Instead of going to the National Signals Bureau account, it went to the account of a company known as Bureau of National Communications, owned by Kwabena Agyapong and his wife. Okay? And then they did what they wanted to do with the money. We have made a decision to charge Mr. Kwabena Agyapong and other accomplices in the Ghana Water scandal separately. Okay, so in a few weeks, we'll be filing separate charges against him. And the amount of money in the Ghana Water scandal is in excess of 62 million Ghana cedis. 62 million Ghana cedis. That Ghana Water, that sometimes does not have money to pay for chemicals to purify your water, had to part with purportedly for the government agency. That's what happened. And so, because the contract documents stipulated that the payments be made to Bureau of National Communications, Ghana Water then demanded that the check payments be made to National Signals Bureau because of the change in the corporate identity of BNC. What then happened was that every time the check was made out to National Signals Bureau, and it landed in the accounts of National Signals Bureau, Kwabena Agyapong, as Director of National Signals Bureau, would then immediately write a check to himself and transfer the money. From our investigations, you can see the movement of the money. Immediately it comes from Ghana Water, he signs a check and transfers the money into the, his personal company account. Now, today something happened in court. Counsel for the defense told the judge that whatever I had said was a figment of my own imagination. But of course, he is entitled to earn his fee. So he can say that. I have been briefed constantly and regularly. I've seen the evidence.
That's the Attorney General. I said you've seen the evidence. And Oliver, you're making a point very quickly on writer Bright Simmons had put out. Very quick one.
Yes. No, I was talking about Bright Simmons writing, talking about how a company with the same name and initials as a state agency which was changed to National Signals Bureau, we allowed that to be set up, almost cloning the national security apparatus, in order to receive payments in the name of payments intended to the National Security Signals Bureau. It's a bigger issue beyond theft or allegations of theft, but goes into bigger national security issues, which must then requires to do a bigger audit of the national security space itself. Because this is something that is compromising the nation's security, I would think.
I see. Thank you. As Samuel Atachian said, lawyer Martin Kwebu, it's a dangerous somersault by the Attorney General in this particular case, and having his client in the coolest of the Economic and Organized Crime Office, that's Kwabena Agyapong, for 7 days, as we saw yesterday. Then again, fundamental question is, what exactly was done wrong? Is it a sentiment you agree with or you share?
To be straight, it's not possible, to put it very simply, it's not possible for me to either agree or disagree with Atachian. I say so because, I wasn't there, so I didn't hear what they said in chambers. You see, it tells you that to the extent that they had to go into chambers to deal with certain parts of the case, those parts, or that part of the case is sensitive. So I wasn't with them in chambers, so I haven't heard what the Attorney General said and what he Atachian counted. So to the extent that we've been disabled from hearing that, it's impossible to side with him. Of course, I wear a very big hat in this part of the law when it comes to bail. I think I've done my bit when it comes to bail. At least I've taken 3 different decisions, 3 different cases to the Supreme Court, and they all went well. Of course, it's because it's the Supreme Court that's interested in expanding the frontiers of personal liberty. So you have Kwebu number 1, Kwebu number 2, Kwebu number 4, right? Yes, different chief justices. So yes, I have a soft spot when it comes to bail generally, but it all depends on the actual facts of the case. The Attorney General made a request and the judge agreed that they should go into chambers. So only the 2 lawyers went in there. Even you, the media, you were not allowed in. So everything that was said in there is more or less like a closed book. Nobody in camera.
Yes.
And when it's in camera, how am I now going to say, oh, well, okay, let me just go with my emotions because for me 48 hours is 48 hours, etc. Then I must go with Atachian. No. So even to the extent, you see, to the extent that Atachian himself didn't even reveal what happened in chambers, then it tells you that we have to tread cautiously. You see, that's his client. He hasn't revealed what happened in the judge's office, or like we say, chambers. He hasn't revealed it. So once he hasn't revealed the specifics, it means that nobody is in a position to side with one or the other. So in such a case, you give what we call a margin of appreciation to the judge. It's a judge who heard it, and based on his judicial discretion, went on to remand the accused for 7 days. So it's not possible. It's not possible.
He says this is a travesty of justice, playing with the liberty of an individual, essentially. And that's where you gravitate towards in your earlier submission that, yes, you align, you are on record, and indeed having contributed to the legal jurisprudence in this country as having fought for bail.
Yeah.
But
different decisions over starting from 2015 to 2019. 3 separate Supreme Court decisions. People number 1, they used to jail people, right? If the accused absconded, which is wrong. I took it to court, so that was the first decision, December 2015. Then the Supreme Court said, no, we'll strike this down. Then May 2016, the non-bailable offenses case. There were about 12 offenses. If it was slapped on you, that was it. You wouldn't get bail generally until the end of the case. So even if it took 10 years, whatever, you would stay in, right? Yes, and we saw that it was such an abuse. The Supreme Court looked at it. That's the Georgina Wood court. Yeah, Georgina Wood stood there and said, no, this thing is going down. Then, of course, people number 1, 2 was still under Georgina Wood, right? Then, Georgina Wood left. Then Sophie Kufu came in 2019. People number 4, that's the one that weekends, the police will wait. When it's Friday, then they come take the suspect or accused, knowing that Saturday, Sunday, there's no court. So that by Monday, the person would have sweated in custody, etc. Sophie Kufu, that was her valedictory judgment, the last one, meaning very dear to her heart. That was the decision she gave, and then retired from the Supreme Court, right? Said no, 48 hours is 48 hours. Come rain or shine, right? So they subsequently just CJ Eniyebua gave directives on how to access the court during weekends, public holidays, etc. I've done about 5, 6, right? And you see even the recent elections, you see that the NDC and the NPP, you see on public holidays, they were in court. Yes, that's consequent upon that decision, because in people number 4, then the judiciary broke free from the executive. They made it very clear that the president cannot determine for the judiciary when the court sits. So they determine Saturday, Sunday, public holidays, they will sit because it's an essential service, you see. And since then, you know, so we are growing. Of course, some lawyers, especially in the hinterlands, have to access the courts on weekends, but it takes time. They also have to get up and fight, because Chief Justice Eniyebua gave the directive. So it's for you to push the registrars, right? Whether you are in Boko or Navrongo, wherever, right? So yes, all these decisions show that I'm very keen, I have a strong passion for personal liberties, right? Very strong. But like I said, that is the theory. Those are the principles. The principles have to be applied to specific cases. The Attorney General says Edu Boahen is interfering. As to how he's specifically interfering, we don't have that.
Because it was in chambers.
Done in chambers. So in that case, but of course, so I mean, I can't. There's no way any lawyer, I mean, who is seized with all the facts can castigate one part and then say the other one is right. Except that, of course, so now I'm looking at it that, you see, there is this part of the law that I'll be interested in, which we have to get up and fast track. You see, the house arrest. Because when you have a better home, why wouldn't you ask for house arrest? So the one, they will even wear you an anklet. You say, so you are chained to your home. If you step out, the thing is connected, like the tracker, the ones they put in the cars. If you step out of the house, it will show that you've breached the conditions. So house arrest, I think we yes, because Dubai has over 30 houses at least. They say yes. You see, a man who has over 30 houses is being kept in the Yoko cells. So that side, yes, but that's the state of the law. We don't seem that bothered. And often it's these politicians who have to be, because they are the ones who go and they have access to all of our money, but they don't pay attention to how we should reform the law. Today you have about 30 houses, but they say stay in the Yoko cells. You see that thing? Just like the way I made it earlier on, I said it earlier that when Chief Justice Torkonoo was being vetted, they asked him, what do you want changed in this constitution? The first thing I heard with my own ears was that the president should not have a role in the discipline of judges. CJ Torkonoo took over. I don't remember her calling a debate on how we should start to amend the constitution. And then 2 years on now, that very thing she said we should change is being used against her. You see that thing? So when you get a big position, you should be thinking forward. What should we do to improve? You see the situation? So let's think seriously about it. This matter of house arrest, you know, we should. It's long overdue. Because a lot of the time, even by the time you become minister, etc., on average, you would have a couple of houses. Yet, when you get trouble,
we'll put you somewhere.
Go and throw it somewhere. You know, it's like we like punishing people. And our law is very clear that we shouldn't use bail to punish an accused before the conviction of the accused. You see, we shouldn't use bail. We shouldn't use bail to do that. You remember Oliver is here. You remember how Oliver and Co were treated a few months ago. And you see how we're very strong. We didn't miss when we took on the judiciary. We called out the judges left, right, center. That no, that was wrong. You see, but these things keep happening. They keep happening. We say we will not work hard to improve the law. Our laws are so archaic. The Act 30, 1960 law. 1960 law. Act 30. Yeah, how clairvoyant could people have been in 1960 that they could have seen everything that will happen in 2025 and written it down? No. But the law is so archaic, extremely archaic. And then once in a while, you see the politicians who make efforts at amending, then it doesn't go far. Yeah, there were attempts. I remember in the past, Justice Doche was involved, etc. But you know, the Attorney General then it disappeared. Then we did some colloquia, we did symposia, then Justice Ifya Asaribochi, you know, the Court of Appeal judge. When she sees us, she say, hey, maybe you guys are interested in amending Act 30 or not? And also Act 29, Ifya Asaribochi. She says it. Are you interested or not? So maybe with this, when the boahen comes out, she should probably be leading the charges because he is feeling it now. Of course, and all of us here, all of us here. Oliver has suffered it, we all know. Had not been for Domahine, you see, granted Oliver bail. And when Domahine granted Oliver bail, see how they threw him off to outside Accra and all that Domahine suffered, you know.
Waiting for winning and someone about better. Yapon so Mikao says, so when you subscribe to channel idea, Bobody say over subscribe. No, I like video, no, give us a thumbs up, now fee, share my offer so now when you be here. Na and somewhere koso ewo Ghana memoir. Also with me actually wadwen afaye somewhere nyina ho ewo comment box mu. Mbati minkabi in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.